The lawsuit was filed on a Tuesday, 41 days after my grandmother's funeral. I know the exact number because I had already been counting. I am a paralegal. I have worked in estate and probate law for 11 years. I have sat across conference tables from people contesting wills, contesting trusts, contesting the basic arithmetic of grief, and I have helped attorneys build the paperwork that stops them cold. I know what a no contest clause looks like. I know what it costs to trigger one. And I know, because I read my grandmother's trust the same afternoon her attorney handed it to me, that my Uncle Dennis had just signed away everything she left him the moment he filed that suit. He did not know I knew. That is the story. Welcome to Calm Revenge Tales, the channel where quiet people keep the receipts, and family learns that boundaries have a price. If you've ever watched someone mistake your composure for weakness, and then had the privilege of correcting them, you're in the right place. Drop a comment, hit subscribe, and let's begin. My grandmother's name was Loretta. She was the kind of woman who pressed flowers between the pages of her Bible and balanced her checkbook to the penny and never, in the 81 years she was alive, said anything she didn't mean. She grew up in a house without indoor plumbing, put herself through secretarial school on a seamstress salary, and bought her house, a yellow Craftsman on a quarter-acre in a neighborhood that has since tripled in value, in 1974 for $32,000. She paid it off in 11 years. She kept the deed in a fireproof box under the bed, in a manila envelope labeled, in her handwriting, mine. I am her granddaughter on her daughter's side. My mother, Loretta's youngest, died when I was 22. Pancreatic cancer, 8 weeks from diagnosis to gone. After that, I moved closer to my grandmother, not because anyone asked me to, but because she was 83 and still driving herself to the pharmacy, and I was the only one in the family who seemed to find that alarming. My professional credential is not incidental here. I became a paralegal because of my mother's death. She left no will. No beneficiary designations updated after her divorce from my father. The small savings account she had, $14,000, went into probate and took 16 months to resolve, during which I was 22 and paying my own rent and learning what it means when someone leaves without a plan. I went to school. I learned the language. I became someone who helps other people avoid the thing that happened to my mother's $14,000. My grandmother appreciated this more than she said. She used to call me her document girl. She meant it as affection. She called me that the day she introduced me to her estate attorney, a soft-spoken man named Gerald, and said, "She's the one who understands all of this, so she's the one you talk to." That was March of the year before she died. Gerald looked at me across his conference table and said quietly that he was glad someone in the family had come. He said it like it meant something. I filed it away. My Uncle Dennis, my grandmother's only son, her firstborn, the one who had her nose and her stubbornness and exactly none of her financial restraint, lived 40 minutes away and visited approximately 4 times a year. Christmas, Easter, her birthday in June, and once in the fall, irregularly, when he needed something. He was not a cruel man in the way that makes strangers uncomfortable. He was cruel in the way that families absorb over decades. The slow assumption that certain people are there to give and certain people are there to receive, and that this arrangement is natural and permanent. He called my grandmother Mom in a way that was supposed to land as tenderness, but always landed, to me, as weight. He had 2 adult children, my cousins Brianna and Cole, who had their father's talent for showing up at the right moment and disappearing at the inconvenient ones. Brianna once sent my grandmother a birthday card in July, 2 months late. She signed it "Thinking of you always." My grandmother put it on the refrigerator. She kept every card. I was the one who drove her to chemotherapy when the diagnosis came. I was the one who organized her medications into the weekly pill organizer. She called her Little Rainbow. I was the one who was there when she said, the way she said everything, plainly without theater. I've already talked to Gerald. Everything is in order. I don't want any fussing when I'm gone. I said, "Okay, Grandma." I meant it. I did not yet know how much an order would need to mean. She died on a Saturday morning in October. I was with her. I had driven over the night before because her breathing had changed in the way that people who have been through this recognize. And I sat in the chair beside her bed with a legal pad on my knee. Not because I was taking notes, but because having something to hold kept my hands still. And she was gone before the sun came up. I sat with my hands around the legal pad for a long time after. The phone call started 6 hours later. Dennis called at 2 in the afternoon. He did not ask how I was. He asked, and I am quoting him exactly because I wrote it down within the hour. Did she leave a will? Gerald hasn't called me yet. I told him Gerald would be in touch after the weekend. He said, she told me the house was going to stay in the family. I said, I'm sure Gerald will explain everything. He said, I just want to make sure nothing got mixed up at the end. I wrote that down too. Mixed up. I underlined it. Gerald called me on Monday morning. He asked me to come in Thursday, and he said, and he had never said anything like this to me before. I want you to read through everything before the family meeting. I think that's what she would have wanted. I drove to his office Thursday afternoon. He handed me a copy of my grandmother's revocable living trust, fully executed, dated 14 months prior. He let me read it at the table. He brought me coffee without asking. The trust was 37 pages. I read every one. My grandmother had left the house, the yellow Craftsman, assessed at $480,000 mortgage-free, to me. Outright. No conditions except one. I was named sole trustee and sole beneficiary of the residential property, and all contents therein. The trust also included a savings account of $62,000, a small brokerage account of about $18,000, and a life insurance policy with a death benefit of $100,000. The house and its contents came to me. The liquid assets were divided, per the trust's terms, among her 4 grandchildren equally. Me, my 2 cousins, and a cousin on Dennis's side I had met twice. Approximately $38,000 each, after taxes and administrative costs, per Gerald's estimate. Dennis received his father's pocket watch, a specific armchair he had admired, and an antique radio that Loretta's own father had owned. These were itemized by name in the trust. She had thought about them. She had chosen them deliberately. He received nothing liquid. He received nothing real property adjacent. He received objects. And then I turned to page 31, where the no contest clause lived. A no contest clause, also called an interim clause, is a provision that says, if you challenge this document, you forfeit whatever it gave you. It is a firewall. It is a grandmother saying in legal language, I thought about this. I was not confused. I was not coerced. I knew what I was doing, and if you suggest otherwise, you lose even this. Gerald had drafted it in clean, unambiguous terms. Any beneficiary who initiated legal proceedings challenging the validity of the trust, or who made any claim that the trust was the product of undue influence, diminished capacity, or fraud, would be deemed to have predeceased the trustor, and their bequests would pass to a named charitable organization. The local library's endowment fund, which my grandmother had supported for 40 years. Dennis stood to lose the pocket watch, the armchair, and the antique radio. In the grand scheme, they were objects. But they were her objects. And I think she knew, in the way she knew everything, plainly without theater, that taking them would hurt him in a way that money wouldn't. I read the no contest clause 3 times. Then I read it a 4th. Then Gerald slid a second envelope across the table. He said, she asked me to give you this separately. It was a letter. In her handwriting. Dated 8 months before she died. I folded it and put it in my bag. I read it in my car in the parking garage, with the engine off and the windows up. I am not going to read most of it here, because it was hers and it is mine. But there was one line I will give you, because it is the line that held everything else up. You were always the one who stayed to do the hard thing. I don't want you to spend one more year of your life apologizing for that. I sat with that sentence until my hands stopped moving. Then I drove home and I made a list. The family meeting was the following Tuesday. Gerald's conference room, same table. Dennis arrived with Brianna, which I had not expected. Cole sent a text at 8 that morning saying he couldn't make it but to fill him in. I arrived 12 minutes early and sat across from the door. Gerald presented the trust. He walked through the distributions clearly, and without editorializing. He named the no contest clause. He explained it. Dennis was quiet for approximately 45 seconds. Then he said, "She wasn't herself at the end." Gerald said, evenly. The trust was executed 14 months before her death. At that time, Mrs. Loretta was assessed by her physician as fully cognitively competent. I witnessed the signing myself. Dennis said, "My daughter influenced her. She was always over there." Brianna, to her credit, looked at the table. I said nothing. Gerald said, "The trust is valid and duly executed. I'm happy to answer questions about the administrative process." Dennis said, in a voice that had gone very quiet and very specific, "I want to contest it." Gerald paused. He looked at Dennis. He said, "I want to make sure you understand the no contest clause and what it means for your bequest." Dennis said, "I understand what it means. I want to contest it." I looked at my hands. I thought about my grandmother sitting in the chair by the window in October, the way she folded her hands in her lap when she was waiting for something to be over. I said, "Dennis, you should talk to an attorney before you make that decision." He looked at me as if I had said something remarkable. He said, "I've already talked to one. The lawsuit was filed 41 days after the funeral. Undue influence. Diminished capacity." The complaint listed me as the primary respondent and alleged, with some elaboration, that I had leveraged my professional knowledge and proximity to my grandmother to steer her estate planning in my favor during a period of cognitive vulnerability. I printed the complaint and read it at my kitchen table with a highlighter. It took 20 minutes. I highlighted 4 specific factual claims and 2 characterizations of my behavior that I could directly contradict with documentation I already possessed. Then I called my own attorney. Not Gerald. Gerald was the trust's attorney, technically neutral. I called a woman named Patricia, who I had worked alongside for 6 years and whose practice included probate litigation. I told her I was bringing her a no contest clause case. She asked me to send her the trust. I had already scanned and emailed it before she finished asking. She called back in 40 minutes. She said, "He's already forfeited the bequest by filing. In this state, the no contest clause is enforceable on filing, not on outcome. He lost the pocket watch the day he signed the complaint." I said, "I know." She said, "So what do you need from me?" I said, "I need you to defend the trust, and I need you to make sure he knows in writing what it cost him to file." She said, "That I can do. If you have ever watched someone mistake your patience for permission, if you have ever sat in a room while people made plans around something that was yours, you already know what happens next. Stay with me, because the part where he found out is not the part one expected. It never is." For the next 6 weeks, I received calls. Some from Dennis, some from Brianna, who had apparently been appointed the family's emotional intermediary. One memorably from a cousin I had not spoken to in 4 years, who opened with, "I just think there are 2 sides to every story," and closed with, "We're all family here." I wrote each call in a log. Date, time, name, summary. I did not record them. I didn't need to. I simply noted them. A paralegal is, at her core, a person who knows that the thing you write down today is the thing you can read aloud in a conference room 18 months from now. Dennis called me on a Thursday evening, 3 weeks after the filing. I let it go to voicemail. He said, "I think we should talk. I think we can resolve this without it getting ugly. Call me back." I saved the voicemail. I texted Patricia, he called. "Wants to resolve your move." She sent a letter. Formal, accurate, and precise. It laid out the no contest clause in plain terms, confirmed that the filing had triggered forfeiture of his bequest under the trust terms, and noted that the defense of the trust would be funded, as permitted under the trust terms, by the trust assets, meaning that every dollar Dennis spent on litigation was, in effect, reducing the inheritance pool he claimed he was protecting for the family. He was suing his mother's estate with his mother's money, and he was losing his mother's objects while he did it. Patricia sent me a copy. I read it the way I read everything. Once for comprehension, once for gaps, once for the thing the other person will think they found. I found nothing. It was clean. I did not call Dennis back. Brianna came to my apartment on a Sunday afternoon, 6 weeks before the hearing date. She knocked. I answered. She had brought nothing. No casserole dish, no plant, none of the material gestures the women in my family had always deployed at difficult moments. She stood in my doorway in a good coat and asked if she could come in. I said yes. I made coffee. I sat across from her at my kitchen table, where I had read the complaint. She said, "He's not going to win, is he?" It was not quite a question. I said, "What does your attorney say?" She said, "I don't have an attorney. I didn't file anything." And then, after a pause, I told him not to. I looked at her. She had her grandmother's eyes. I had never noticed that before. She said, "She loved you. We all knew she loved you. That's not the same as saying it was fair to the rest of us." I said, "No. It's not the same thing." I didn't say anything else. I didn't offer her comfort that wasn't mine to give, and I didn't offer her absolution she hadn't asked for. I poured the coffee and let the silence sit where it had earned its place. She left 20 minutes later. She said at the door, "I'm sorry about the lawsuit." "I mean that." I nodded. I did not say it's okay, because I had spent 11 years helping people understand that silence at the right moment is not the same as agreement, and I was not going to spend my own words on something that wasn't true. After she left, I took my grandmother's letter out of the folder where I had been keeping it. I read it again. I placed it back in the folder. I put the folder in the fireproof box I had inherited along with everything else, in the box that had once held the deed my grandmother labeled mine, in her handwriting, which was the most precise and careful handwriting I have ever seen. The hearing was a Tuesday in February. Gerald testified about the trust execution and Loretta's cognitive state. Her physician testified briefly via written declaration. Patricia presented the timeline, not just the trust but the years of documented engagement. The tax returns she had filed, the prescriptions I had filled, the invoices I had paid from my own account before being reimbursed, all of it logged and dated and printable. The professional intermediary trail. The visit records. The phone logs. Then Patricia presented one more document. It was a letter. Not the letter in the fireproof box, a different one. This one my grandmother had written to Gerald 18 months before she died and asked him to hold, unopened, until the trust was in probate. Gerald had told no one. He had simply held it. It was 2 paragraphs. The first paragraph explained her reasoning for her distributions in plain terms. That I had been present, that I had contributed, that she had watched her family's attendance record over 2 decades and made her decisions based on what she had observed, not what she had been told. The second paragraph was addressed by name to Dennis. Gerald read it aloud. One line from it. "I always knew you would do this, Dennis. I hoped I was wrong. The fact that you are reading this means I wasn't." The courtroom did not go quiet dramatically. It was already quiet. It just stayed that way for a moment longer than usual. Dennis's attorney asked for a brief recess. The judge gave them 10 minutes. When they came back, his attorney stated that his client was withdrawing the lawsuit. Patricia stood and said precisely, "The trust notes that litigation costs shall be deducted from the litigating party's share of the estate. We ask the court to confirm the forfeiture of the bequest per the no contest clause, and to order recovery of attorney's fees and costs against the plaintiff." The judge confirmed it. All of it. Dennis's attorney said something quiet to him at the table. Dennis did not look up. I looked at my hands. I thought about my grandmother and the legal pad and the chair beside her bed and the October morning. I did not feel what I expected to feel. I felt, mostly, tired in the way that you feel tired when something you have been bracing for is finally over and your body is trying to remember how to stop holding itself. On the way out, Brianna was in the hallway. She had come. She had not been called as a witness, she had simply come. She looked at me and she nodded, a small, specific nod that meant something she didn't have words for. I nodded back. That was all. The trust closed 4 months after the hearing. The house transferred to my name. I had the deed recorded at the county registrar's office on a Wednesday morning. And I drove to the yellow Craftsman afterward and sat in the driveway for a while. The attorney's fees and costs Dennis owed the estate came to $22,000 and change. Patricia recovered them in full. That money went back into the trust pool and was distributed to the 4 grandchildren according to the original terms, which meant that I, Brianna, Cole, and the twice-met cousin each received a slightly larger disbursement than initially projected. Brianna's share landed at just over $40,000. Cole's at the same. I did not contact either of them about it. Dennis lost the pocket watch, the armchair, the radio. The library received the bequest in their place, a donation, acknowledged in a small letter Gerald forwarded to me, that funded a reading room expansion. The plaque on the wall of that room carries my grandmother's name. The armchair is in my living room now. I did not keep it as a claim. I kept it because it was the most comfortable chair she owned, and because she sat in it every evening and read. And because when I sit in it now, with a legal pad on my knee and something to hold, I can almost hear her saying, "Document girl." Dennis, to my knowledge, has not spoken to me since the hearing. Brianna called me once in the fall to tell me she had updated her own will. She said it like she was telling me something important. I think she was. Cole texted 6 months later asking if I wanted to get coffee sometime. I have not responded. That file is still open. The letter in the fireproof box, the one my grandmother wrote to me, the one I read in the parking garage, is still in the fireproof box. I have read it 4 times total. The box lives under the bed in the room where I grew up, which is now a guest room in my grandmother's house, which is now my house. The box is labeled, in her handwriting, which I traced once with my finger in the dark, mine. I have not changed the label. I think about the things she wrote sometimes. The line I gave you earlier. You were always the one who stayed to do the hard thing. I don't want you to spend 1 more year of your life apologizing for that. I have not apologized. Not once. Not in the conference room, not in the courthouse, not in my doorway when Brianna stood there in her good coat. I have been precise and I have been documented and I have been, in the way my grandmother taught me by example before I was old enough to name it, absolutely and specifically myself. Calm is not the same as weak. I knew that before any of this. My family had simply never believed me. There is a difference between revenge and stopping payment. Revenge is a withdrawal from someone else's account. What I did was close a ledger that had been running at my expense for years. Quietly, with paperwork, the way things actually get closed. My grandmother understood the difference. She spent 14 months making sure I would too. The reading room at the library opened last spring. I went to the opening. I sat in one of the chairs and read for an hour. Nobody there knew who I was. I brought a legal pad. Old habit. I didn't write anything. I just held it. Some things you hold not because you need them, but because your hands know what it means to stay. If this story reminded you that the people who stay and do the quiet, undramatic, unglamorous work of showing up are the ones the careful ones plan for. If it reminded you that calm is not the same word as resigned, take that with you. Update your documents. Have the conversation you have been deferring. Tell the person who showed up that you noticed. And if you've ever been the document girl, or the document person, in a family that mistook your composure for an open door, I hope you know. Composure is a door that locks from the inside. Drop a comment. Tell me which part stayed with you. Subscribe if you want more stories like this one. Quiet people, hard truths, and the paperwork that outlasts everything. I'll see you in the next one.